Provisional and complete specification. Section 9. Provisional and complete specifications. Contents of both the specification. Every specification, whether provisional or complete, shall describe the invention and shall begin with a title sufficiently indicating the subject matter to which the invention relates. If the controller so requires, the drawing shall be supplied for the purpose of any specification, whether complete or provisional. If the controller considers it necessary that the application shall further be supplemented by a model or sample of anything illustrated the invention, such model or sample shall be furnished. Every complete specification shall fully and particularly describe the invention and its operation, describe the use and the method by which the invention is to be performed, disclose the best method of performing the invention. To get advantage of a prior date of the patent, provisional specifications are filed. Also, the applicant should file the complete specifications within 15 months after filing the provisional specifications. Patent agent rights and qualification. Patent agent is an agent who is registered under the Act for the purpose of filing a patent application on behalf of the patentee in the patent office. Rights of a patent agent. Section 127. To practice before the controller, prepare all documents, transact all business, and discharge all functions before the controller. Qualification of a patent agent. He should be a citizen of India. He has completed the age of 20 years, 21 years. He has completed the age of 21 years. He has degree in science, engineering, or technology. He has passed all qualifying examinations for same. He has functioned for not less than 10 years as an examiner or discharged function of controller. He has paid fees as prescribed. Let's understand GI, geographical indication. It is an indication. It originates from definite geographical territory. It is used to identify agricultural, natural, or manufactured good. The manufactured good should be produced or processed or prepared in that territory. It should have a special quality or reputation. Benefits of registration under geographical indication. It confers legal protection to GI in India. It prevents unauthorized use of registered GI. It promotes economic prosperity of the producer. Who can apply for registration, which is not compulsory? Association of persons, producers, or organization. Applicant must represent interest of producer. The application should be in prescribed form. Application to be addressed to the registrar of geographical indications along with fees. Category of goods discovered in geographical indication. Agricultural goods includes production, processing, trading or dealing. Natural goods includes exploiting or trading. Handicrafts or industrial goods. Assignment or transmission. Geographical indication is a public property of the producer. It cannot be assigned or transmitted. Write a short note on appellate board. Central government by notification establishes an appellate board known as Intellectual Property Appellate Board to exercise jurisdiction, powers and authority conferred on it by or under the Act. Composition is chairman, vice chairman and such number of other members as the central government may deem fit as per the Act. Qualification for appointment. Chairman. A person should have been a judge of High Court or has held office of vice chairman for 2 years. A person should have held office of judicial member or a technical member for 2 years. Vice chairman. For appointment, he should for at least 2 years held office of judicial member or has been a technical member of the Indian Legal Services or has held post in grade 1 or any higher post for at least 5 years. Judicial member. A person shall not be qualified unless he has been a member for the Indian Legal Service grade 1 for at least 3 years or has for at least 10 years held a civil judicial office. Terms of office. The chairman, vice chairman or other member shall hold office as such for a term of 5 years or until he attains in the case of chairman and vice chairman the age of 65 years and in the case of member the age of 62 years, whichever is earlier. Salary and allowances. The salaries and allowances shall be such as may be prescribed. Resignation and removal. The general superintendents of the chairmen or the appellate board may decide on the matter. Write short note on Anton Pillar injunction. Anton Pillar orders are a form of civil search warrants that help preserve evidence. The aggrieved approaches the court in an urgency and seeks inspection and raid of the premises of the alleged wrongdoer without prior notice, in order to find and preserve evidence that it believes would otherwise be destroyed. Explain design requirement for registration. The Designs Act 2000 briefs the requirement of as follows. Any person claiming to be the proprietor of any new or original design may apply for registration of a design to the controller. The design must be unique. Prior publication is not acceptable. Making application. The applicability of the design should be to the article itself. The design must not be contrary to the order and morality. It should be related to shape, pattern, configuration or ornamentation of the article applied for registration. The design should be significantly unique and distinguishable from other known designs. It should not be obscene, scandalous or contrary to the morality. It should not attract the provisions of section 4 of the Design Act. What is the difference between copy and patent? Copyright and patent. Owner can reproduce and distribute original work of his without any hassle. A patent is granted to the invention which is the creativity of the owner. Copyright is an automatic right which protects the original literary, dramatic, musical and artistic work. A patent is a registered right that gives the owner exclusive right to his invention. Copyright protects someone's literary and artistic skills. Patents are used for inventions or discovery. A work must be original, creative, and fixed in a tangible medium. A patent invention must be new, useful, and non-obvious. Terms of protection. Terms of protection. Terms of protection is of copyright is author's life plus 20 years. Terms of protection for patent is 20 years. Difference action of infringement and passing off. Action for infringement. It is a statutory right. Passing off. It is a common law. Action of infringement is applicable only to goods. Passing off applies only to business or services. Action for infringement is applicable to registered trademark. Passing off is applicable to unregistered trademark. Passing of infringement need not necessarily lead to passing off. Passing off need not necessarily lead to infringement. If marks are identical or deceptively similar to it, no further proof is required. In passing off, identical or similarity of marks, not sufficient use of the likely mark must be likely to deceive or cause confusion. An action for infringement is a statutory remedy. An action for passing off is a common law remedy based on an action for deceit. Defendant must use the infringement mark on the same goods for which the plaintiff's mark is registered. Defendant's goods need not be same, it may be allied or even different. Use of the mark by the defendant need not cause any injury or damage to the plaintiff. Use of the mark by defendant must be likely to cause injury or damage to the plaintiff's goodwill.